This courtroom hearing reveals a tense custody battle where a judge steps in after an emergency order involving a young teenage girl. Concerns about the father's past alcohol use, unstable environment, and the child's emotional safety take center stage. As both sides present their arguments, the judge carefully balances the truth, the child's voice, and the law to decide what happens next.
Petitioner appears by Zoom separately from his attorney, Mr. McClendon. The respondent appears by Zoom separately from her attorney, Ms. Goheen. This was a quick hearing scheduled as a result of an ex parte emergency order that I signed based on an affidavit submitted by mom involving their daughter. I was thinking she's, I don't know if she's 13, 14, or 15.
13.
13. She seems much older. Anyway, it did reference some 911 calls and some information that I don't want to get into on the internet with some incidents occurring. And one of the issues with regard to Dad, Mr. McClendon, has been voiced previously. And I did an in-chambers interview with their daughter. I'm trying to remember, we don't have the notes here, but I think it was around the Christmas holiday or in between Christmas and New Year's. And she's very bright. She loves her dad and her mom. But there's too much drinking at that household and too many chaotic things. And she does not want to go there while that's the state of things. And he hasn't been working for quite some time, and I just don't think there's been any real stability there. And she likes Douglas, her school, her friends, and she's doing well. That was the information I got. And I don't all that often with teenagers just do what they express, because I don't think they always know what's in their best interest, and a lot of times they have ulterior motives. I just don't see that with this young lady. I've said before that these parents have had to have done a good job because they have a grown daughter that is very well adjusted and does very well. And they've obviously done well with this child, based on just how she presents herself and what I gleaned anyway. But there are just things going on that aren't working well for the co-parenting schedule. And so that's why what I'm trying to express is that this wasn't just emotion. I had background, had talked to the daughter, knew what she was voicing and what mom was voicing as some concerns and some complaints. I admonished mom this last fall about putting her into Douglas and about doing things outside of the court parameter, including not denying any visitation. And I also talked to the daughter that I needed her to go on that weekend visitation. I needed her to try to maintain a relationship with her dad. And she said she would try. I mean, she said she understood why I would be asking her and ordering that she do that. But then this all sort of erupted, and I've got some concerns about forcing her to do that, frankly. So I'd like to hear from you if there are things in the affidavit that are just simply not true. I certainly need to know that. I'm sure there's some opinion there, but I mean, as far as the major incident and what occurred, if if it's not true, then I need to know if there's something else going on.
Well, yes, Your Honor. I guess first things first, I'd probably want to question Mr. Boyer. Here, we've talked about it, but if we're going to go about this, would you want to do it in an evidentiary matter or format? Or essentially, Your Honor, I think like we don't deny that the incidents happened, but maybe to the extent that they're being reported that they happened, that's more so what we're denying. Essentially, my client, he's been sober off of alcohol for approximately 4 months now. The hallucinations he was having were alcoholic withdrawals, but he hasn't had those since that particular incident. And again, that's been approximately 4 months. I've talked to him. He's open to the idea of getting a drug and alcohol evaluation if the court would prefer that. He doesn't feel like it's necessary at this time. He's also willing to submit to a UA here today. He did say he does participate with THC gummies, but he hasn't had those in approximately a week and does not plan to, use those while in parenting. So, in that particular issue, that would be our explanation. And then, in regards to stepmom, Miss Tara, she's seeking psych help with crosswinds. Not to divulge into that too much, but
right.
That issue is being handled as well. They're doing what they can to provide a safe home, and I do not think, other than obviously probably the child's willingness to not go, I don't think there would be any issue with having continued visitation there.
Well, I think she does. I don't think this is all prompting by mom. If you'd asked me, before I interviewed her or 6 months ago, I might have thought it was prompting by mom, but I
During the hearing, the judge highlights serious concerns about the father's household, including past drinking issues and instability. The child, described as mature and intelligent, expresses that she does not feel comfortable staying in that environment. Despite her love for both parents, her preference raises important questions about safety and emotional well-being.
I think that this is her using her voice, but mom is CMB in therapy?
Yes.
And how often is she going?
Once a week.
And I don't have my notes. I don't remember if we talked about that.
Yeah, we have.
No, I mean, I don't know if when I talked to her in private whether I talked to her about. Well, I wouldn't ask her about her therapist sessions or anything like that, but I should have a social file somewhere, Amy. I know I took notes. Anyway, how often is she going to therapy?
Once a week.
And who with?
Jerry Lynn at South Central Mental Health in Andover, Kansas.
Okay. Ms. Goheen, have you requested any kind of report from her?
Judge, I have subpoenaed records. I have not, as of yet, requested a report. I'm sure we could do that, and probably we do need a report from her. in order to determine what her assessment is as of this point. I was planning to subpoena her to the time of trial, because as you know, I got into this case after the first evidentiary hearing was scheduled, as did Mr. McClendon. But I certainly am more than willing to ask her for a report. This just came about all of a sudden, obviously, and based on the court's prior concerns, I wanted to gather documentation of whether or not this occurred, and we got the records from the police department. Before I filed this, I called Mr. McClendon, who is a pleasure to work with. He contacted his client. His client's response was he denied all allegations, which is a bit concerning to me when we come here today, and now he's admitting these incidents did occur. But certainly, and I have no doubt this child loves her dad. I mean, it's evident that his stepdaughter loves him from the affidavit that she provided to this court. But there are issues that are very serious going on in that household, as I think the court has pointed out.
Okay. Well, truthfully, I would rather you get a report than get the records, which may have sensitive information that I wouldn't even want mom to see. So be careful with that, please.
Judge, if you want those to be an in-camera review, I'm perfectly.
I would. I really,
Okay.
I really want to respect her privacy. And I think if she thinks that people can just get that information whenever they demand it, that it may affect, her relationship and how she feels about being in counseling, especially if there's really something significant. I mean, even just involving her, not the parents. So
I will
I
direct.
would appreciate that, but I would like a report so that we had an idea, like how she may testify if she's called to testify.
I will direct a letter from my staff to, I think we subpoenaed the school counselor as well as the therapist. So I'll direct a letter from my staff to go out to both of those entities to send those documents directly to your chambers. If we happen to get them, I will direct my staff to make sure they are just sent straight to you.
I've already signed a release at South Central to send all records to Judge Satterfield
Okay.
when
I'll
she
follow
started
that.
counseling. Okay, thank you.
Yeah, I don't think I've ever gotten anything that I'm aware of, but. All right, so our trial's 4/1 of 26. I don't know if I could get you a trial any sooner. I'm inclined to suspend continue with the temporary emergency order and suspend visits right now until trial. And I'm going to ask Mr. McClendon that your client get a hair follicle. Specifically, I mean, they'll do everything, but what I'm looking for is alcohol usage. I'm hopeful that 4 months would produce a negative result. If that's the case, I honestly do need him to get an evaluation, because if he's past first of all, if you have withdrawals, that's pretty significant in and of itself. But if he's past the withdrawals, but he hasn't sought any treatment or support, I'm concerned about his ability to be successful in the long term, which should be his goal given the way things have impacted their lives. But I would like to, if they say, you know what, he's done the hard part, he understands the steps, or he understands what this entails, he can do it without any outpatient, he's shown that he can do it, great. If they say, you know, he really would benefit from an outpatient treatment program, that may be something we need to look at. Is Dad back to work yet?
I'd have to defer to my client, Your Honor.
No, not currently.
Okay. I don't know what his finances are in terms of a car or in terms of anything. I would like to consider, between now and the trial, Dad being able to go to Douglas and take her out to eat or something. Sir, are you going to any of her activities or school things at all?
Last one I was notified of was like 3 months ago, and that's all I've known. And it was a music choir.
And that was the last one.
Okay. Doesn't he have access to the school?
He does. He receives letters from Douglas.
Okay. Ms. Goheen, what would be your client's position about the daughter going to a therapy session and discussing with her therapist, visiting with her dad about his efforts for sobriety, and seeing him in Douglas for a dinner or evening or a few hours rather than going to Eureka?
Well, Judge, number one, I think we need the results back from the hair follicle and maybe the assessment. But I don't believe my client would have a problem with him coming there to go to lunch so long as he is sober. I would have suggested a sober link, but I don't know where he's at in this process. But so long as he's sober, I don't think that would be an issue for him to come and have dinner with this child, particularly after she discusses that with her therapist.
Okay, well, that's going to be my order. If he has an appointment scheduled, if he's done his hair follicle, and if she's seen the therapist so the therapist can answer her questions and talk to her about it, then I think that her knowing what's going on with her dad and seeing it for herself is important. And so I'd like to see that happen before, you know, if, you know, possible. I think it should be before the trial, since the trial's set out a ways. And then everything else is just going to have to go to trial. I mean,
Judge,
this is where they're at. I've got to make a final decision about what this is going to look like, at least for the near future, summer, etc.
Judge, if I may,
Yes.
could we request the mom get a hair follicle as well? Dad, father's led to believe that there may be pills or other opioid use going on within the home, and we'd be requesting that.
Okay.
I mean, it would at least
The father's attorney responds by explaining that he has been sober for 4 months and is willing to take drug and alcohol evaluations. However, the court remains cautious, emphasizing that past behavior and long-term stability matter more than short-term improvements. The judge makes it clear that proof and accountability are necessary before any decisions change.
Even the playing field on the aspect of drug usage is more so the reason I request it. I say even playing fields. Right now,
What?
if Dad's on having to put in all the work here, which I understand he's playing from a disadvantaged spot, but I think in order for that would be appropriate at this time.
Well, I can tell you from the daughter's perspective, she, like I said, she's really very mature. And she's pretty articulate. And she is aware of Mom's past history and issues. And she knows what Mom is like when she is abusing pills, and she has not indicated any concern or voiced any concerns about Mom being back in that cycle.
I've been sober for 9 years.
And but she has Dad, so I can tell you that. I can also tell you that if I do order it to be mutual, where I don't have a present circumstance that I think just would warrant it on the court's own motion or request, that he would have to pay for her test. If it were positive for something she does not have a prescription for, or she shouldn't be taking, then perhaps I would order her to reimburse him, but he has to front the money. That's usually how I find out how serious people are, and they are the ones that request it and spend the money to have it done for the other side. So, Ms. Goheen, your response?
Judge, I would agree. I had that discussion with my client before. If Mr. Boyer wants her to take a test, absolutely we will. We'd ask that he pay the upfront cost. And then if the test, contrary to what my client tells me, is positive, she would reimburse. If it's negative, like she tells me it will be, then he's stuck with the cost of it.
Yeah. So that's what I'm going to order, Mr. McClendon, and you can talk to your client and decide what he wants and communicate that with Ms. Goheen. But most people at the cost of it are it makes them only want to do that if they have some real certainty of what they believe the results are going to be. So it's up to him, but he does have to pay for his, and if he wants her to have one, he can talk to you, and when he fronts the money for it, then she'll get one too. But meanwhile, I need all these other things in play. I am trying to positively move towards some contact. I don't think, if he really is making strides, that no contact is necessarily what's best, but I do want it to be on her terms and in a structured environment, and he is going to have to express to her the changes that have been made or that are being made, and I want her to have a chance to visit with her therapist. And so those are the orders that I'm going to adopt today, and then otherwise we'll see, what all comes out during the trial.
Judge, just so we're clear, are you requesting that Dad pay for his own hair follicle as well?
Yes.
Okay. I mean, I was just wondering because originally Miss Boyer did request that in an earlier document.
Well, I mean, I know what his history is, and he is the one that's representing to me, the judge, that he's been sober for 4 months, and I want to see it. So I'm going to order that he do it, and that he paid for it, and that he get a drug and alcohol evaluation.
Judge, is there a time frame in which you want him to complete those items?
Well, no, but he can't have visits with her. If he wants to drive to Douglas and take the time and the commitment to do it, he can't visit with her until it's done. I mean, I at least want the hair follicle done and the result, and then at least an appointment. If he's got an appointment for a drug and alcohol and he's got a negative follicle, then I'm not going to make him actually wait until he's had the evaluation and we have a report in hand.
Sure.
So it's
I
up
guess-
to him. If he doesn't want to do anything until April and just wants to try the case, that's fine too.
And Judge, I guess while I'm here, since there is a possibility it does come back positive for his hair follicle does because of usage, what would be your requirements for him to, say, 2 clean UAs to be able to still exercise those visits?
Then I'll want to see the results of the drug alcohol report
Okay.
before anything else happens. And you've already told me about the gummies. I don't know that I'm going to let that, if it's a small amount, stand in the way that he uses for sleep. I mean, it's illegal in Kansas. It's not illegal with a prescription in Missouri or Colorado, or not that, or Oklahoma. I mean, not that he couldn't get in trouble for it, but I'm just saying I'm more focused on his alcohol usage, which tends to change people's personalities when they're under the influence sometimes, and their decision making, than the gummies. Although I do think it's important when he has his drug and alcohol evaluation, he talks to the counselor about that, because I understand you said he's stopped that this last week, but I mean, you can't be sober and use substances, even if it's small quantities of gummies, THC. I mean, I just don't think how those programs work. But let's just take it one step at a time, and you guys get back with me if you've got some results and you're a little confused, or you want to take it up with me on what you have or what's going on. Just let me know. We can do a quick conference, or maybe even just an email exchange or something. But otherwise, I think the path is pretty clear on what needs to transpire, and then we'll just have our trial as scheduled.
Judge, we have a motion on docket next week, which I think most of this is addressed, because we have things like interlock device, but if he's not driving her, then that's not an issue. But we also have a child support motion. I'm not asking to establish child support, but my client's still paying child support. There was a child support hearing. That judge deferred to whatever you're going to do with respect to child support. But I don't know why
my child since August.
You what?
She's had the child since August.
I know.
Support.
We had the child support hearing, and the judge stated that he would let you address it in this motion.
I think she had arrearages.
Yes.
I think you're correct.
And so
Yes,
he probably
I
just
called today and she still owes $1,998.42 in arrears. Plus they have stopped child support. I haven't got child support in almost about 2 months now.
They're actually holding the child support, Judge. That was what the court trustee would be doing. And I'm guessing that with the amount that Mr. Boyer would be paying, those two would be offset. And we can figure that out at trial. But certainly, I don't think she should be continuing to pay child support as of right now, because she's already been paying since August, when the child was with her before even August.
Right.
So I'm just asking it be terminated, and then everything else we can figure out, whether she owes any arrears, and what he should have been paying.
Okay.
So I don't need, that's all I'm asking for, is for it to be terminated as of today.
That's fine. Then it's not gonna get rid of her judgment. I mean,
Right.
it may be terminating, but I'm not suggesting that there isn't a arrearage and a judgment that can be collected. But it can be on hold until we get it all sorted out. And I would think that's something, now that you're on board, that we could have sort of at least a rough draft, depending on the outcome of the hearing, but sort of a rough draft from both of you based on what your clients are asking for and what you're proposing. So we do need to shore that up too, and we'll try to do that right around the 1st or shortly thereafter. But in the meantime, it can be suspended so you can take a look at what they're holding, where she's at, how much she owes, and he can get a judgment for that amount, and we can figure out the arrearage payment, how much he owes, and how that's going to offset. So,
do you want me to do a simple order, Judge, that simply says the child support is suspended, and at the time of trial we'll assess what the arrearage and what he should have been paying?
As the discussion continues, the court considers therapy reports, school life, and the child's routine. The judge shows concern about forcing visitation and instead suggests a structured and safe approach. The idea of supervised or limited contact is introduced to rebuild trust without putting the child at risk.
yes.
Okay.
And Judge, just for clarification, this case is set, it's a 4D case, it looks like, so it's set with Judge Murphin on May 1st at 2:30.
Okay.
Does that hearing need to be canceled, or do you want me to leave it there?
They can find, in fact, I shouldn't really do anything without notice to DCF
Right.
to modify anything or do anything.
And Ms. Hawks wasn't aware of today's hearing, of course, but I can give her notice of anything moving forward if necessary.
Well, what I'm going to ask you to do, Ms. Goheen, is let her know that I approved your request, and let her know so that she can contact the court if she objects,
Okay.
because she should have been notified and she should be heard whenever we're talking about child support. Yeah, now I see the 5/126, but I see JT scheduled before Judge Satterfield on 4/126. Okay.
And
About that, I was thinking they were deferring to me, but that's not really what this note says.
I will tell you, when we were there, DCF and I discussed it with the judge, and he said he wanted to see what you were saying.
All right.
And so DCF agreed to hold the payments on child support.
Okay. Well, I think I'm going to suspend it until we can get some good numbers and see where everybody's at. But I don't want them, I don't want them giving her that money back. I want them to
No.
hold it. Okay. All right.
I'll put in the order that any funds that DCF is holding will remain in their possession.
And then I don't care if you do it separate or part of the order. Maybe do two separate orders. One that addresses the child support, and then another one that continues the emergency order. and all the provisions and the contact, and that it will all be taken up at the time of trial that was previously scheduled for April 1st.
I will do that, Your Honor.
Okay. Anything further, counsel?
No, Your Honor.
Would you be interested in appointing a CASA member to this judge?
I don't think so.
Okay, I was just curious. I was just curious to maybe try to get a unbiased third party in there.
Okay. Let me tell you when I usually do CASAs. When their homes are in totally different locations and totally different lifestyles and, totally different situations, or when they borderline child in need of care. That's most frequently. If I think there's a kid that between both parents may be hinging on being a child in need of care, which I don't think this child is, I do order CASA. Counsel, I appreciate your request, and I know why you're asking for it, and I understand that, but our trial is so fast approaching. I don't think it's very fair to a CASA worker. Their priorities are child in need of care. When they do a domestic case for us, they do it sparingly, and I try to really reserve that for cases that I have serious concerns, and often it's kids who can't speak for themselves, or they don't have attorneys, or the attorneys are not pushing forward to get reports and talk to teachers and get, any of that stuff. I could give you some examples of some of the cases if you wanted that I have utilized. It's pretty minimal, but I just feel a need to protect their resources, and they really weren't developed for domestic cases as much as they are child in need of care. And I think this child can talk about what she thinks her best interests are. I think you guys can argue it. I think you can get the records that you need. I think that we just don't need boots on the ground, and I just don't think there's enough time, or should we expect to appoint somebody that's volunteer and ask them to be ready for trial on April the 1st. So
I understand, Your Honor. I just
I promise.
figured I'd inquire,
Okay.
given the particular situation, but I also understand your point of view on that.
Okay. You can ask it again, or there can be other things that I can look at, but we're just so close to trial. I just think this is a case that needs trial, and I have two able-bodied attorneys that are going to be the ones gathering up the stuff, and you guys getting ready to go. So, all right, if there's nothing further, we're adjourned. Keep in mind, please, I am out of the office from Saturday, February 21st until Monday, March the 2nd, that I schedule any trip I take like this where I'm unavailable the previous July, and I do not generally have much contact with the office when I'm gone during that time. So I just want you to, if there's anything we need to do, please put that on your calendar, that you're going to have a hard time reaching me. Now, I will have some limited emergency coverage, but it will be up to the chief judge what anybody's willing to do or will do in response to whether they actually consider it an emergency or they want to do anything. So please put that down, because I know there's a lot that's gone on. I understand this was a emergency order. I understand that we're close to trial, but please know that you're not going to be able to probably reach me much during those dates. Okay? All right. I appreciate it. Thank
Hey,
you, everyone.
Judge.
You're adjourned.
Just so we're
Yes.
clear, are we canceling next Thursday?
I don't, let me look. Were we
I
gonna
think
do
we tackled pretty much
conference order?
everything
I
here
don't
today.
know. I know what the issues are. I mean, I don't know do you think we need a pretrial conference order?
I do think we need a pretrial conference order so opposing counsel and I can assess who the witnesses will be.
But that could be more of an exchange 14 days prior to trial.
That's fine with me. I don't have a problem with
I
that.
mean, what's the chances that you guys are going to have an agreed pretrial order by the 19th?
Well, that's fair.
You might be able to do a questionnaire, but that's not totally helpful to me if you don't put it together in an order. Let's see, we got Thatcher. We got oh yeah.
Don't think we need that hearing
We
next.
had it for an hour, and that was a motion. Was that your motion?
That's my motion, Judge, and I think you've
okay.
addressed everything
Okay.
that's priority.
No reason for your clients to pay more money for a hearing, especially if we're not going to have a pretrial conference order. And if you did, I would just let you submit it. So yes, I'm going to take you off the docket if that's all right with you.
Thanks, Judge.
That's fine
I'm
with
going to ask that you exchange witness list and exhibit list 14 days prior to trial. So I don't know, where's that put that? April
1st, a Wednesday, so
that puts that at March 18th.
yeah.
Yeah.
Now my question, we're only scheduled for a full day. Is that going to be enough time for this?
I don't know, I hope so.
I think so.
We're open
I
the
think you should.
second, but
Well, then I would suggest that we leave that next morning open.
okay.
I'm not open the second.
You're not? Okay.
Okay.
I can, if we want to start at 10, I'm with Judge Hart, I believe. Let me see here. Yeah, I'm with Judge Hart on his Greenwood County docket.
I
Yeah,
would
I've
judge.
heard they are doing those like in the morning and then they finish up stuff and then they're done by afternoon, which I haven't figured out how they do that because
We're usually done by 10 or 10:30,
okay.
depending on
I
the
have
case.
an all-day trial on the 3rd,
Okay,
Judge
okay.
Ricky.
Well, that means if you guys figure out you need more than a day, I still have time on the 31st. Or you're gonna have to give each other a half day to present your case. So I only have it scheduled for a day. All right, and let me know as soon as possible if you want to do an afternoon or anything the day before. I've had to bifurcate if we just absolutely couldn't get done. I've had to set the hearing a few weeks, later to finish it up, which isn't ideal, but my hope is that you put together your case, you have your witness list, you have your exhibits, you know who you're going to call, and you work around a time frame of each getting a half day.
In the end, the judge orders temporary suspension of visits until further evaluation and evidence are provided. The focus remains clear. The child's safety, stability, and well-being come first. With a trial approaching, this case is far from over, and the final decision will depend on what both sides prove next.